Hi everyone, and welcome back to the autumnal series of Monday morning dispatch videos. What I'm trying to pick out is live, albeit anonymised cases that we are advising on, and one piece of advice that has come up this week relates to an individual's removal at the insistence of a client and what happens next. So in the particular example of this video, we have a company, an employer, that operates a series of security contracts with clients. So they will place their employed security guards on particular sites and workplaces. So what happens if the end user client who has one of these security guards says, for whatever reason, I don't want that person being placed on my site anymore, remove them and find me somebody else? That can cause issues, particularly in smaller employers where we might not be able to redeploy, or where the location of the particular site might cause issues in moving somebody on and off that contract. The first point to check when removal is required is the contract. What can we do under the contract in terms of place of work? Ideally, the place of work clause would have great flexibility in terms of where the employee can be placed, and it would be very poor drafting if the only place of work they could be put on was a particular client site. So hopefully the contract gives flexibility in terms of moving them about, and ideally we can find them a redeployment opportunity on another client site. But what happens if that's not possible? For example, what happens if there are no other vacancies within the business, or this particular site is very far away from any others and it's very far away in terms of travelling distance for the employee, such that we genuinely can't put them anywhere else? Many employees in this case would say, well, the role's redundant, the employee can't do it. That's not technically the case. There is no reduced need for the work to be carried out. The business still has to put a security guard onto that site. The issue is more that we can't have that physical employee doing that role, and there is a reduced need for that employee rather than the business to perform that work. It's also probably not a conduct issue, so unless we are actually dismissing for a gross misconduct matter prior to the client demanding removal from site, we might not be able to rely on conduct as a reason for dismissal. Often clients may ask for removal from site because there's a personality clash, or they perceive that somebody's not working at the level that they want. So that could be a conduct, it could be a performance issue, but more often than not it's short of the business being able to simply end the contract. So in those circumstances we look at what we call some other substantial reason, which is a catch-all fair reason for dismissal, and there are various different types of issue which can fall into an SOSR termination. The substantial reason in this case is the client's desire to have that person removed from site and our inability to do anything else other than dismiss. Crucially, the first step we have to take is a persuasion exercise with the client themselves. So the tribunal will be looking at the employer to do everything they can to save that employee's job. That starts with speaking to the client, understanding why they want to remove, and trying to agree on that employee staying on site, perhaps with, depending on what the issue was, an apology, some coaching, a different way of setting the work up, but the employer showing that they've done everything they can to try and change that client's mind. If that's not possible and the client insists, we are then looking at potential dismissal by reason of some other substantial reason, but looking at any alternatives we can. So this is where we look at trying to find other work for the individual. Can we place them on another site? Can we find them other work, perhaps even with adjustments to their working hours if travel might be an issue? Is there anything else that we can do to prevent having to terminate employment? Once all of that has been exhausted, at that point we will be looking at whether or not we bring the contract to an end, which would be on notice rather than as a gross misconduct issue. So at the point at which an employer faces a scenario such as this, there are a number of steps to go through before a fair dismissal can be justified, and it's crucial that the reasoning is correct for that dismissal in the circumstances. If you do need any further advice on this or anything employment law generally, please do get in touch. Visit the website chadwicklawrence.co.uk or email employmenthub@chadlaw.co.uk. Thank you.